Good morning, everyone. Rob Bonta, California Attorney General here. Proud to be here with my colleagues from New York, Attorney General Tish James, and Michigan Attorney General Dana Nessel. Thank you all for joining us as we announce our latest lawsuit against the Trump administration. This is our 35th lawsuit in 27 weeks, more than one a week, because that's the pace at which this presidential administration is violating the law, trampling over the Constitution. We're here to announce a major legal challenge, one that defends the rights and privacy of millions of Californians and pushes back against yet another unlawful, dangerous overreach by the president. Alongside 20 attorneys general and a governor's office, we're suing the U.S. Department of Agriculture for demanding that we turn over deeply personal data about every single applicant and recipient of the Supplemental Nutrition Assistance Program, also known as SNAP, in our state, and for threatening to withhold funding unless we comply. Let's be clear, this demand isn't about preventing waste, fraud, and abuse. SNAP has very low rates of fraud. That is well known. There are good guardrails already in place. It's about weaponizing government data to intimidate vulnerable communities. People who apply for SNAP benefits have to provide sensitive and private information about themselves and others in their households. And we promise them when they apply that their information will only be used to verify their eligibility and administer the SNAP program. Trump's USDA is demanding that states now violate that trust. The administration's taking a program meant to feed families and is turning it into a tool for fear. That's not just a broken promise, it's a betrayal. You don't promise to help someone eat, then punish them for sitting at the table. And California won't comply. Instead, we're taking Trump to court yet again. SNAP is a lifeline for over 5 million Californians. It helps working families, seniors, children, and people in crisis put food on the table. But now the Trump administration is demanding that states turn over personal, sensitive data, names, social security numbers, home addresses, even for people who applied years ago. It's a bait and switch of the worst kind. SNAP recipients provided this information to get help feeding their families, not to be entered into a government surveillance database or be used as targets in the president's inhumane immigration agenda. That's the reality here. This isn't about oversight and transparency. This is about establishing widespread surveillance under the guise of fighting fraud. We can call it what it is, an illegal data grab designed to scare people away from public assistance programs. For 60 years, states like California have run SNAP responsibly and successfully with one of the most rigorous quality control systems in the federal government. And all that time, USDA has never once asked states to turn over private and sensitive data on such a massive scale. Now, with no warning, the Trump administration is trying to change the rules in the middle of the game. They're bypassing legal procedures, ignoring privacy protections, and demanding data that federal law explicitly says can only be used for administering the SNAP program. They ignored hundreds of public comments pointing out major flaws in the government's plans. They didn't offer any credible rationale, and they're certainly not following the law. This is a clear violation of the spending clause, federal privacy statutes, and the USDA's own authority, which is why we're asking the court to block this cruel and harmful demand. President Trump made promises to the American people, and now he's breaking them. He's rewriting the rules, targeting the most vulnerable, and expecting states to fall in line, but not California. This is part of a larger pattern. Since returning to office, the Trump administration has been quietly amassing enormous amounts of personal data from federal agencies, including from the IRS and Health and Human Services. Now they're coming for SNAP data. Tomorrow, it could be housing, education, or emergency relief. It's all part of a dangerous strategy. Weaponize personal information to create fear and suppress access to essential services. This kind of targeting doesn't make America safer. It threatens kids' access to school meals. It jeopardizes wildfire survivors' access to relief, and it sends a chilling message. If you reach out for help, you may be punished for it. Not in California. We're fighting back. This isn't just about data, it's about making sure families aren't forced to choose between feeding their kids and exposing themselves to government retaliation. Today's lawsuit defends California's values, it defends the law, and it defends the basic promise that our government should protect the people it serves. Our message to the Trump administration is unwavering. You can't move the goalposts just because you don't like the rules. Rules that have been in place for decades because they work. You can't break your promises and then blame the states for following the law. And you can't use SNAP as a tool for political retribution. I want to thank the outstanding legal team that made today's action possible. They don't do it for the recognition, but I want to recognize them. Maria Buxton, Mike Osgood, Sebastian Brady, William Bellamy, Anna Rich, Robin Goldfaden, Andrew Edelstein, and Ed Wolf on my team. Thank you to a great and committed team getting us to where we are today to push back against this unlawful action by the Trump administration. Thank you. And before we take any questions, I'd like to pass it to Attorney General Letitia James.
Thank you, Attorney General Bonta. The SNAP program is a critical lifeline for tens of millions of Americans throughout our country, and specifically 2.9 New Yorkers. Every day, SNAP benefits make it possible for working families to afford to put food on the table. And more than half of those who receive SNAP are families with children, and more than a third have elderly or disabled family members. Without SNAP, many families would not be able to count on their next meal. For decades, SNAP has prevented people from going hungry and saved countless lives. But now, this administration is attempting to use this program as a tool in their cruel and chaotic targeting of immigrants. It is outrageous. It is unacceptable. And this administration has demanded that states hand over sensitive personal information of all SNAP recipients going back to 2020. That includes addresses, Social Security numbers, immigration statuses, and more. This is not for research or to improve a service that millions count on. No, they are basically trying to weaponize the SNAP program against immigrant communities in violation of the law. And we collectively will not stand for it. That is the administration's plans, and they have made it abundantly clear. They even removed a notice on the USDA's website that promised people could apply for and receive SNAP benefits without immigration consequences. We will not allow this life-saving program to be illegally used to hunt down immigrants and their families. No one should fear for their safety when they seek food assistance for their families. And this administration cannot intimidate vulnerable families and prevent them from putting food on the table. Today, Attorney General Bonta, Attorney General Dana Nessel, and I are co-leading a coalition of our fellow Democratic attorneys general in suing this administration to protect SNAP and the sensitive personal information of all of its recipients. The federal government's demand that states turn over SNAP recipients' data is flat out illegal. In fact, our laws prohibit us from disclosing this SNAP data unless it is strictly necessary for administering the program. And in this case, it is not. This latest action from this administration is nothing more than an attempt to sow fear and to cause chaos amongst vulnerable populations. And we are suing to uphold the rule of law, to protect the sensitive personal information of everyone who receive SNAP benefits, and ensure that this administration does not use critical and necessary food assistance to target immigrant communities. I too want to thank my team. I want to thank my colleagues. I want to thank all of you. And now I turn it over to my colleague from Michigan, Attorney General Dana Nessel.
Thank you so much, AG James. I'm so proud to be here alongside both AG James and Bonta, who have been such leaders in the effort to protect our states against federal overreach from the Trump administration. And of course, to announce here yet another lawsuit to stop the Trump administration from illegally seizing the personal data of more than 1 million Michigan residents. Michigan's SNAP program provides approximately $254 million in critical food assistance every single month to vulnerable families with an average of approximately 1.4 million recipients. And that ranks Michigan 13th among all states in terms of the share of population of participating residents in the SNAP program. We need to be honest about exactly what's happening here. The federal government is demanding 5 years worth of sensitive, identifiable information on every single SNAP recipient in our state, not to improve the program, not to fight fraud, but to create a database and share information with entirely unrelated agencies, including immigration enforcement. This is unlawful, it's a violation of privacy, and it is a direct threat to health and safety of our state's most vulnerable residents. In Michigan, again, SNAP helps more than 1.4 million people every month and delivers more than $250 million in food assistance. It also helps provide nearly 400,000 children with access to school meals. These families applied for SNAP benefits to help put food on the table, not for their data to be stockpiled and weaponized against them by the Trump administration. There's such a difference between protecting program integrity and violating people's rights. And government at all levels has a responsibility to be good stewards over the private, personal identifying information we request from our residents in order to effectuate these programs. And for SNAP, that information goes way beyond what you file in your tax forms. It includes your housing information, landlord contact information, how much you pay for your utilities, even how much you pay in medical debt. When that information is shared, it is with the understanding that the federal government is only using it for its intended stated purposes. And what the Trump administration is doing here crosses that line. State agencies have repeatedly raised these concerns, asking for basic data protections for residents. Instead, we got threats to withhold federal funding unless we comply with their illegal demands. So now, of course, we're doing exactly what we have to do. We're taking this illegal action to court. We will not allow this administration to trample on the constitutional protections or unlawfully exploit the SNAP program to advance their political agenda. Our personal data is exactly that, personal. And this data should remain confidential, protected, and only used by agencies involved with SNAP recipients. Michigan families deserve this protection, and I'm going to keep on fighting until they receive exactly that. And thanks again so much, AG James and AG Bonta, for continuing to lead the fight to protect our state residents. So greatly appreciated.